We have a slight schedule change this afternoon, so leading off our ethics presentation is Carolyn Fairless, a partner with Wheeler Trigg O'Donnell in Denver. Carolyn started her working career as a computer analyst for IBM. She is listed in Best Lawyers for Legal and Professional Malpractice, in Colorado Super Lawyers for Professional Liability Defense, and also its Top 25 Women Lawyers, Law Week's Colorado's Top Women Lawyers, Colorado Super Lawyers Rising Stars, and Colorado Corporate Counsel Black Book for Business Litigation. Carolyn practices extensively in federal and state courts in Colorado, focusing on professional liability, product liability, intellectual property, and commercial litigation. Carolyn's topic today is about attorneys' duty of competency with technology. Please welcome Carolyn Fairless.
Good afternoon. As he mentioned, I'm delighted to be able to kick off the part you've been waiting for, the part where you get ethics credit. And I'm also delighted to be talking about technology, which many of you, I'm sure, are wondering, what does that have to do with ethics? Actually, quite a bit. I'd like to start off by talking about the duty of competence, the very first rule in the rules of professional conduct. And that's Rule 1.1. And what Rule 1.1 says is that you, of course, have a duty to provide competent representation to your client. That means that you have to have the legal knowledge, the skill, the thoroughness, and the preparation reasonably necessary for the representation. Last year, the ABA added a new comment, Comment 8, to the model rule. And what that new comment says is that you don't need to just know what the law says in order to provide competent representation, but you need to know what the technology benefits and risks are for your client. And that is something that is new to the comments, but the ABA said that it is not new to the rules. The ABA said this is simply reaffirming what we believe already existed. It's a reminder to lawyers that you, in advising your clients, have an obligation to talk to them about what technology can do for them and how technology can harm them in the course of your representation. One risk, of course, is that you may say something with technology that you might not have said before. And email, in particular, allows you to say things immediately, things that you may later regret having said. There's a reported Florida bar ethics complaint where a lawyer was suspended and was ordered to take an anger management class as a result of communications that lawyer had with the other side. And there are numerous and sundry emails that they reference in this ethics complaint, but here's just one of them where the lawyer says to the opposing counsel, he starts off, "Old hack, your unprofessional and otherwise asinine behavior is not necessary. Learn to litigate professionally, and these issues will be avoided." After all, my email was in response to your asinine email, insisting on setting a hearing even though there is not enough time. Have a nice day. I particularly love that he's telling the other side to learn to litigate professionally. But if you are thinking about sending an angry email, you get something from opposing counsel, and your blood just starts rising, far more important than sending a quick response is to send a professional response. So draft the email, don't put anything in the 2 lines so you can't accidentally hit send, and sleep on it. And when you come back the next day, think about whether you really want to send it, and maybe you can avoid being that gentleman. And of course, something we've all seen is emails as litigation exhibits. And people saying things in emails that they really wish they would not have said when it gets put in front of a judge or put in front of a jury. And here we've got the in-house counsel talking to the business person, and he's saying, "The court ordered us to turn over all of our internal emails. Have you ever mentioned in email that our products are known to be dangerous, but we don't care?" And the business person responds, "I don't even know what products we make. That's a good defense. We might need it." And it's not just in the cartoon world that this happens. In my home state of Colorado, there was a very well-publicized case where a plaintiff's litigation lawyer, a PI lawyer who advertises heavily on television, He also advertises himself as being justice for victims. That's his moniker. Justice for victims starts here. Well, it turned out when he was sued in a malpractice case that he was referring to a couple of his victim clients as toothless cooties. And in return, the jury in that case returned a verdict of $2 million, including $1.5 million in punitive damages. So be aware that anything that you say in emails can and will come back to haunt you. There are times where just picking up the phone is by far the best course of action. And of course, once you get over the age of 5, avoiding use of the word cooties is also something that is good to do. Now we want to talk about what happens when you are sending information. How can you make sure that technology does not inadvertently cause you to violate client confidences? As you know, under Rule 1.6, you have an obligation as an attorney to protect your client's confidences. And in Comment 18, that obligation includes making sure that there is not any unauthorized or inadvertent disclosure by the lawyer. And the client can also require you to implement special security measures. And if the client asks you to do something in order to protect the security of communications, then you have an obligation as their lawyer to adhere to the client's wishes. Comment 19 states that when you're transmitting a communication that includes information that's confidential under Rule 1.6, you must take reasonable precautions to make sure that information does not end up in the hands of somebody else. Now, one of the things that I'm going to show you is somebody who failed to take those reasonable precautions.
Oh no. Rod, you sent this email, reply all. You hit reply all. You know I was wrong. You just sent this email to me. Could you imagine?
So I'm not going to ask how many of you have found yourself in a similar situation where you wish you could be the guy doing that. But one of the things that you want to do is make sure that you are not the person who's sitting there going, how do I possibly run around and take the computers away from everybody who may have received this? So what does the ABA say about that? First of all, the ABA has a couple of ethics opinions that deal specifically with technological communications, including email. One is Formal Opinion 99-413. And in their formal opinions, the first 2 letters are the year that the opinion came out. So this opinion is actually 14 years old, which by technological standards is ancient. But what the opinion says is that you do not have an obligation as a lawyer to send encrypted email. That if, in fact, you send an unencrypted email, that is not a violation of your obligation to your clients, and that it's reasonable and expected that you may use unencrypted email. However, if there is highly sensitive matter that's involved, further protections may be required under the rule. And these matters may even include avoidance of email altogether if the email cannot be sent in a way such as to sufficiently protect those sensitive matters. That 1999 ABA opinion still exists today, even though there have been arguments that is based on woefully inadequate and obsolete technology. There's a much more recent opinion dealing with emails, and that's ABA Formal Opinion 11-459. And this opinion says that you need to advise your client regarding risk associated with the use of email. And in particular, you need to advise your client if they are using email in such a way that they're running a risk that their confidential communications with you may be compromised. Typically, this comes up with the employee-employer situation. If somebody is employed by a company where there's no reasonable expectation of privacy in their email communications that they're sending from their employer's email address, you, if you are advising that employee, need to explain that to them. and explain to them that they should avoid sending to you any confidential information from that email address. They should set up a personal email address or simply communicate by means other than email. The next thing I want to talk about is beware of the reply all and the BCC. So I think everyone in this room knows of somebody who at some point in time you seriously considered taking away their reply all privileges. And that is something that can be a violation of the rules of professional conduct, the inappropriate use of reply all. How is that? There are two ways that can happen. First, some states hold that it is a violation of the no contact rule if you use reply all to send an email to a represented party. And in this situation, there was an email that was sent to a lawyer by another lawyer, and the opposing party copied the opposing party's client. The receiving lawyer hit reply all and sent an email back to everybody, including the opposing party. And some states hold that that is a violation of Rule 4.2, which says that you cannot communicate as a lawyer with a party who you know to be represented in the matter. So be careful. If you see that the other side has copied their client, and make sure that you understand the rules in your jurisdiction before you hit reply all. When in doubt, when you hit reply, just reply to the lawyer and other people who you want to have receive it. Leave the client off of the communication. Using reply all also can be problematic because you can inadvertently send an email to somebody who you never intended to. There's a case that I've used here as an example, but this happens everywhere, every day, where defense counsel BCC'd his client on communications with the opposing attorney. And the client, not even thinking what he was doing, hit reply all to respond, thinking he was only hitting reply and only responding to his lawyer, and inadvertently copied the opposing side. They went to the court over whether or not that was a privileged communication or whether the privilege had been waived. And the court said that it was a close call. And it said that although the client in that case had taken reasonable, although not maximum steps to protect the attorney-client privilege, the court was not going to hold that there was a waiver. But the court did know that this was the second time that that had happened and warned that the defendant and the lawyer should not expect a similar indulgence from the court in the future. And the court went on to say, they and others should take note, reply all is risky. So is BCC. Further carelessness may compel a finding of waiver. And I think they got off pretty easy, given that this was the second time. I had a situation in my own office years ago where an assistant had sent a settlement demand to the other side, or a settlement offer to the other side, and had copied the client and the insurance carriers on that communication. And somebody on my side hit reply all and copied opposing counsel. It was a harmless communication, but ever since then, I have instructed every person I work with that any communication to opposing counsel can only go to opposing counsel. And then that email, once it's sent, then gets forwarded to everybody else. And that will protect everybody from the inadvertent reply all. Also, beware the autofill. You type things in and it just fills in a name. And sometimes it's not the name that you expect. Make sure to check those emails before you send it. Fill out the to and the CC lines last so that you don't accidentally hit send before you have fully composed your message. And those will help to make sure that you're fulfilling your ethical obligations. Especially with mobile devices, it's very easy to inadvertently send a message that you don't intend to. Flash drives are another way that you can inadvertently disclose confidential information. They're easy to lose, they're tiny little things, and if you put something on it that's confidential and you can't find it, you may have a problem. And you have an obligation under at least the Florida bar opinion to make sure that those devices are protected. So put a big sign on it, put a big ribbon on it, put a password on it. Do what you need to do to make sure that if they contain client confidential information and you lose that device, that you're not compromising client confidences. Next, I want to talk about accessing your adversary's privileged communications. Metadata, as you know, is data within data. It indicates who sent it, information about when it was edited, perhaps information about what the edits were. And so you want to be careful when you're sending your client's data to not inadvertently disclose that information. And in New York, there is an opinion that says that you need to use reasonable care when transmitting documents by email to avoid transmitting that metadata. And that can be as simple as using scrubbing software to make sure that that data is gone by the time the email hits the inbox of the recipient. Now, what if you're receiving metadata? The ABA says you can mine it. What that means is you can actively search for metadata in the documents that you receive according to the American Bar Association. Now, other states view it differently, but at least under the ABA rules, it is up to the lawyer who's receiving the data to make sure, or the lawyer sending the data to make sure that it does not contain metadata. You as the receiving lawyer can do with it whatever you wish if you receive it. But do make sure you understand the rule in your state regarding making that happen. Inadvertent disclosure. If you receive a document, and this is not metadata, this is documents, that you know was inadvertently sent, your duty under the ABA rules is to simply notify. Once you notify, it's up to the jurisdiction you're in, the court that you're in, as to what happens at that point. But the opinion does not require you to do anything other than to provide that notice. And there are some opinions that the ABA has. 11460 is one that I will refer you to that talks about what happens if you receive a document that has been inadvertently sent. There are, of course, some federal rules that talk about it as well. Federal Rule 26 says that if a party produces privileged information or work product, you must either return it or sequester it if you receive the notice first. And then the recipient can seek a court determination. And the real issue here is who provides the notice first. And so the lesson to be learned from this is that if you have sent a document that you think is a privileged document, be the first person to speak up about it. Notify the other side immediately as soon as you learn of the disclosure, so that if you're in federal court or if you're in a state that has a similar rule, there can be some recourse for you and perhaps even a clawback under Rule 502. If you're the recipient and you notify them first, in most jurisdictions, the rules are different, and you're in a better position than if you had received the first notice. So make sure you know your rules, make sure you understand what your jurisdiction requires, and of course, do what you can to avoid being the guy in the commercial who accidentally sent his client confidential information to the rest of the world. Thank you for your time.